Okay, so let's start with the revision of whatever we studied in the last class. What is the meaning of insurance? Insurance is a method of spreading over a large number of persons a possible financial loss. Here, the important word is possible because there is always a contingency attached to it, and also it has to be a financial loss, it has to be a pecuniary loss, right? Which is too big or too serious to be borne by one individual. Whatever loss which is like impossible for one person to bear, if we are distributing or if we are spreading that financial loss amongst a large number of people, then that method is known as insurance, right? So here what happens, the loss suffered is shifted to a willing and capable professional risk bearer. So who is the professional risk bearer in this case? The insurer or the insurance company is the professional risk bearer, right? Now we know this is that this comes under union list, and then we studied the history of insurance, like initially how it was governed by the Companies Act 1882. Then Life Insurance of India, Life Insurance Corporation of India Act 1956 was passed. Then General Insurance Business Nationalization Act 1972 came, and how privatization happened in the insurance sector. We also studied what are the two routes of FDI in India, and also we studied that now the percentage of FDI through automatic route has been increased to 74%, right? And beyond 74%, it is not allowed. Hi Gunjan. Okay, so which group are you preparing for, Gunjan? Write in the comment section, chat box below. Yeah, and also beyond 74% it is not allowed because 75% में SR pass होता है, right? So that big decisions cannot be made by any foreign investor. So for that reason only it was made up to 74%. No government approval is required for any foreign investor to invest in an Indian company for long term, or we can say for equity purpose, right? Okay. Utilities we studied, these are very easy things, so I'm not describing it again and again. Yeah. We also studied one more thing, that insurance companies are regulated by IRDAI, Insurance Regulatory and Development Authority of India. But incorporation of any insurance company is done as per the Companies Act, as per the Prevalent Companies Act. Whatever Companies Act is there in the country at that particular period of time, according to that insurance company, it is done, right? Also, we studied how many parties to any insurance contract is there. So one is insured and another one is insurer, right? So who is an insured? Insured is the person who seeks protection against a specific risk, right? And that insured person, okay, Gunjan is preparing for group 3, very nice. And that insured person is entitled to get money from the insurer in the event of happening for which that insured is insured, right? जिस particular reason के लिए उसने लिया था insurance, for that reason if that particular thing happens, so in that case only the insured is going to get insurance, or is the insured is going to get protection. In simple words, in the exam, if you are unable to like recall whatever words you are supposed to write, you can simply write this particular thing. Yeah. So who is an insurer? Insurer is a person, and in most of the cases it is an insurance company who underwrites the insurance risk. You can remember the word underwrite, right? So the person or the company who underwrites the insurance risk is known as the insurer. And who is the insured? The person or organization who is covered by the insurance, or the person who is going to get money in case of any uncertainty, in case of any contingency, or in case of any happening of the event for which that person is insured, right? Okay. So so far 5 persons have joined. Okay. Yeah. So, in today's class, we will start with the kind of insurance, right? How many kinds of insurances are there that we are going to study in today's class? Okay. So, insurances are basically of two kinds. One is life insurance and one is general insurance. So, we all are having a little bit of idea on what is the meaning of life insurance, right? Because every day we keep on listening about LIC, right? LIC is very popular in India, and I think most of our parents are having LIC for themselves, and also for a few of you, LICs must be there. So, according to section 2, clause 6b, right? This is not subsection, this is clause 6b. First, we will understand what is the meaning of general insurance, then we will understand the meaning of life insurance, right? So, general insurance is defined in section 2, clause 6b, where it says that, now look at the second point. Here it is said that insurance contracts which do not come under the ambit of life insurance. Ambit means the scope of life insurance. Okay, that is known as your general insurance. So, fire, marine, or miscellaneous insurance business, whether carried on singly or in combination with one or more of them, is known as general insurance. So, it includes fire insurance, marine insurance, or miscellaneous insurance. Now, what do you mean by miscellaneous insurance? For example, I want to insure my smartphone, right? So this comes under the miscellaneous insurance business. Okay, so all these things they come under general insurance. Motor vehicle insurance and also health insurance comes under general insurance. Now, a lot of people get confused that health insurance is a part of life insurance, but no, it is not a part of life insurance. It comes under the definition of, or the scope of general insurance only, right? I hope this is clear. Now let's understand what is the meaning of life insurance. Now, life insurance is defined in section 2, clause 11, where it says business of effecting contracts of insurance upon human life. This needs to be underlined, upon human life, including any contract whereby the payment of money is assured. Payment of money is assured on which event? On the event of death or happening of any contingency dependent on human life. Now we are talking about contingency dependent on human life, which means any contingency. Contingency means any uncertainty which may happen or may not happen, right? So here we are talking about happening of any contingency which is dependent on human life, right? For example, I have done an insurance for my mobile phone, right? And something happens to my phone, so this does not come under the ambit of life insurance. Why? Because this is not dependent on human life, right? And also here one more thing is included, that it shall be deemed to include granting of disability. So it means any event, any contingent event has happened which grants the insured disability. Disability means uh, कुछ नहीं कर पाना. For example, something happens with your leg or something happens with your hand and you are unable to do, you have become disabled, right? So in that case, what happens, that also comes under the scope of life insurance. So what is the important thing here? The contract of insurance affects the human life. This is the first keyword that you need to remember. Second keyword is payment of money is assured. Payment of money is assured, that is the second point. And the third point is the event. What is the event? Death or happening of any contingency dependent on human life, related to human life, right? So this includes granting of disability and 2x or 3x indemnity accident benefit. What is the meaning of indemnity? Indemnity simply means granting security, right? Or we can say providing protection. Indemnity means it is going to provide double or triple protection against the accident which has happened, right? Now, the second point says granting of annuities upon human life. So, it also fetches you annuities upon human life. Now, the third point says Granting of superannuation allowances. We all have studied in inter what is superannuation allowances, right? And benefits payable to the relief and maintenance of persons who are dependents or employees or engaged in any trade with that person. So here, whenever this word comes, relief and maintenance, so three persons should come to your mind. One is the dependent of the insured, second is the employees of the insured, third is the business partner of that insured person, right? So this is the definition of life insurance. Okay, I know this is a bit confusing, but you simply need to remember 3 points. Sorry, you simply need to remember 6 points. The first point is that the contract should rely on, or the contract should be regarding human life. Second point says that payment of money is assured. Third point says that what is the event, right? You just simply remember the word event. Event is death or happening of any contingency dependent on human life. Fourth point says that it grants disability or double or triple indemnity accident benefits. Fifth point says the annuities on human life. And the sixth point says superannuation allowance and benefits payable to relief and maintenance of dependent employees and business partners. Right? I hope this is clear to you. Okay. Now we are coming to the definition section, which is given in the book itself. So, out of which, whatever points I have tick marked, only those are important for your examination. The first is policyholder. So, I am not going to elaborate this because in the last class I had mentioned you what is the meaning of policyholder. So, policyholder is basically the insured person or who is having the interest of policy, right? That person is the policyholder. Now, the next important definition is controller of insurance. So, who is the controller of insurance? So, controller of insurance is the officer officer who is appointed by the central government to exercise all the powers, discharge the functions, which means to perform the functions, and perform the duties of the authority. Whenever we say authority, it means IRDAI, right? We are talking about Insurance Regulatory and Development Authority under this act, or Life Insurance Corporation Act, or General Insurance Business Nationalization Act, or IRDAI Act. So, controller of insurance is the officer appointed by central government. Now, when we are talking about court, it means the principal civil court of original jurisdiction in a district. So, jurisdiction means you can say, for example, I stay in Rourkela, right? So, it comes under the like any case, any civil case comes under the jurisdiction of Rourkela court. So, this is the meaning. Okay. Now, health insurance business, this also you can understand simply by reading this. Indian insurance company, uh, in my opinion, no question can be asked from definition section, but in some of the long questions you might require to write the definition of these things, right? So Indian insurance company also you can simply read and understand. There is no difficult words mentioned here. Now, insurance agent. So insurance agent, I think we meet every other day. We meet any insurance agent who is supposed to sell you some kind of policy, insurance policy, right? So insurance agent means an insurance agent who receives or agrees to receive payment by way of commission or other remuneration in consideration of his soliciting or procuring insurance business, including business relating to continuance, renewal, or revival of policies. So basically, he's an insurance agent who receives or agrees to receive some kind of commission or remuneration simply by providing you services regarding continuance, renewal, or revival of insurance policies, right? Now, what is the meaning of investment company? We know this is very easy. I think in July 23 term we got an MCQ from this, like what do you mean by an insurance company? So whose principal business is acquisition of shares, stocks, and debentures and other securities those are known as investment companies, right? So this is also one important thing, because in the last term we got an MCQ from this particular concept. Okay, now the last definition that we need to understand is reinsurance. Reinsurance means the insurance of part of one insurer's risk by another insurer who accepts the risk for a mutually acceptable premium. Now, we all have studied the contract costing chapter, right? So, since we all are in finals, so we know what is the meaning of subcontracting, right? From a big contract, we subcontract some part of work to another agency or to another person who can do this much of work for me, right? So, similarly, from a big insurance, if you are if you are delegating some part of insurance to another insurance company or to another insurer who also accepts the risk for mutually acceptable premium, right? That person is also going to get some amount of premium. That concept is known as reinsurance, right? So keep in your mind, whenever you see the word reinsurance, it is very similar to the concept of subcontracting. Okay, so yeah, with this we are done with the definition part, and now we are going to start with the principles of insurance law. Okay, so till now, do you have any doubts? If you have, then do write here in the chat box. Okay, so I'm assuming nobody is having any doubt. So yeah, so there are generally seven principles of insurance law. Seven principles and two more points which are given in a CMA book. So all those two important points are points also we are going to cover here. So the first point is good faith. The first principle is principle of good faith, or we can say principle of utmost good faith. This is very important, utmost good faith, because if you have attended the last class, I think Shivani had attended the last class, Deepak Gunjan also attended the last class. So I told you that the major difference or the fundamental difference between a normal contract and a contract of insurance is requirement of good faith, right? Because we have studied the 10 elements of a valid contract in our CMA intermediate days. So there we had studied 10 elements, but if you see that clearly, then good faith was not there. But in case of insurance, it is there. So good faith is a fundamental principle of insurance law. Now, the concept of good faith is based on a Latin maxim which is known as Uberrimia fidel. Uberrimia fidel. So, if you are able to remember this particular phrase, then only you write this in the exam. अगर याद नहीं रह रहा है, then don't force yourself to write this in exam, because it's better not to write than writing the wrong one, right? So, a contract of insurance is the contract which is of utmost good faith, which is known as Uberrimia fidel, right? So, both the parties to the contract, both insurer and the insured, are required to observe utmost good faith, and both the parties should disclose every material fact. Here, one more important thing is that both the parties are supposed to disclose whatever facts are material or whatever facts are relevant for both of them to know, right? So for example, I am getting a insurance policy for myself, right? And for example, I'm having diabetes, and I tried to hide this particular information from the insurer or from the insurance company, right? Because I'm making a life insurance for myself. So in this case, every detail regarding my health is important, right? So in this case, I am having diabetes. This is a very important thing. This is a very material fact. This matters a lot, right? And somehow I on the date of a blood test, I took lots and lots of insulin, and somehow I was successful in hiding the fact. So this, if the insurance company is proving this particular thing in the court, then in that case what happens, I am breaching this principle of good faith, right? I hope this is clear. Now the next point we have studied. Now this says the burden of proof to show non disclosure or misrepresentation is on the insurance company. So this means that the insurance company has to prove that I being the insured, lied to the insurance company regarding my diabetes, right? So this speaks about that. So whenever we are talking about the principle of good faith, in this case, the like I have to, like the insurance company needs to prove who is guilty, right? If the insured has hidden some fact from the insurance company, so the insurance company has to prove this particular thing, right? Now the next thing says that what is the legal binding. Legal binding means um, legally what you are supposed to do, right? So legally you have to act honestly and not mislead other party with incorrect or incomplete information, which means both the parties, both insurer and the insured, are supposed to act honestly and disclose every material fact, and both of them are required not to mislead the other party with incorrect or incomplete information, right? I hope this is clear. So now the last point is also very important. The duty of good faith is continuing in nature. What is the meaning of continuing? Continuing means कॉन्ट्रैक्ट के साथ भी, कॉन्ट्रैक्ट के बाद भी, which means at the time of making the contract and also during the contract you have to observe. Sorry, what is this? Yeah, at the time of making the contract and also during the contract you have to observe good faith, right? When you are making the contract and even during the continuance of the contract, you have to you should not hide any material fact to each other, right? I hope this is clear. Now we are coming to the next principle of insurance law, which is the principle of misrepresentation. Now, in CMA Inter, in Indian Contract Act, we have studied misrepresentation, but in this case, this is a little bit different. Okay, so before understanding misrepresentation, let's understand what is the meaning of representation. So, representation means statements made by one party to the other, either prior to or while entering into an insurance contract. So, any statement which is made by the insurer to the insured or by the insured to the insurer while entering into the contract or before entering into the contract regarding any matter relating to the insurance contract, but it is not an integral part of the contract. Now, this is important. It should not be an integral part of the contract, but if the representations or if the statements made by one party to another is an integral part of the contract, then they become warranties instead of misrepresentation, right? They become warranties. What is the meaning of warranty? We have studied this particular thing in Sales of Goods Act 1930 also, difference between conditions and warranties, right? So, the very same concept is applied here also. The Insurance Act lays down three conditions of willful misrepresentation. Now, the word willful is very important because willful shows that the person, either insured or the insurer, has done the misrepresentation with an intention for this, right? ऐसा नहीं है कि उसने जानबूझ के नहीं किया है, उसने जानबूझ कर ही किया है, right? So what are the three conditions? If these three conditions are satisfied, then it can be proved that the misrepresentation has happened willfully, right? So the three conditions are: statement must be on material matter, it should be on material matter, and it should suppress facts, right? It should either be on material matter or it should suppress any fact which are material to disclose, which means if you are suppressing any fact, for example, if you are hiding any truth, if you're hiding any important fact regarding your health while doing your health insurance or life insurance, so that is a material matter, right? So statement must be on material matter, and you must be suppressing that fact, right, which is supposed to be disclosed. You are suppressing that. So this is the first condition. Now the second condition says that the suppression must be done fraudulently. Fraudulently, it means it should be done by, like, by doing any fraud. Fraudulently it should be done, right? So by the policy holder. In this case we are talking about the insured. If the insured is doing the suppression fraudulently, for example, the example I took a few minutes ago regarding I have diabetes, but while doing the blood test I took so much of insulin that I that my blood reports came normal, and I also hid the fact that I have diabetes or I have sugar issues, right? So all those things are known as suppression of the fact, that too fraudulently, right? Now the third condition says that the policy holder must know at the time of making the statement that it was false. It was false. So it means, for example, I spoke a few things in the condition of anesthesia, right? Before getting operated, and I was being मतलब मेरे को anesthesia दिया गया था, and उस condition में I told you a few things. So it is not considered as fraudulently, right? Because while making the statement or while making the representation, I was in all my senses, and I knew that what I am saying, right? I knew that I am making a false statement. Only in those cases, this particular thing will be known as misrepresentation. The statement suppressed facts which were material to be disclosed. So the policy holder must know at the time of making the statement that yes, I am making a false statement, and also that I have the statement that I made has suppressed a few facts which are material to be disclosed, right? I hope two principles are clear to you. The first is principle of utmost good faith, or we can say eubermia fidel. The second is what? The second is about your principle of misrepresentations, where you need to satisfy three conditions. Okay. Now, the next principle is the principle of warranty. Now, what do you mean by warranty? So, warranty basically means some kind of promise which has to be complied with, which has to be strictly complied with, right? Now, so warranty has nowhere defined in the Insurance Act, but in the Marine Insurance Act, warranty has been defined as a promise. It is a promise where the assured or the policyholder or the insured person undertakes that some particular thing shall or shall not be done. For example, I'm getting a policy, I'm getting an insurance policy for myself, right? So in this case, I am undertaking or I am promising that during the continuance of the policy, I will not do a few things or I shall do a few things, or some conditions shall be fulfilled and some facts should be affirmed or shall be negated for the existence of the policy, right? So in this case, this is known as warranty. For example, uh, while making an life insurance policy, the condition says that I anything, if any health issue happens to me, or after the policy is done, if I did a blood test and after 1 or 2 years I got any disease, so in that case what happens, some conditions has to be fulfilled. Means if I am getting any disease after 1 or 2 years of getting the policy, then it is my duty, it is my utter duty to let the insurance company know about this, right? So some conditions shall be fulfilled. I just gave you one example. And some facts can be affirmed or can be negated. Like I have to affirm a few facts. For example, the thing of any health, getting any health issue. right? So during this continuance of the insurance policy, I have to do a few things, and I have to promise this particular thing, right? So that promise or that undertaking is known as your warranty. Warranty must be strictly complied with, and any breach of warranty means avoidance of the policy. Any breach of warranty will lead to avoidance of the policy, whether the breach is material or not. Now, in the first two principles, materiality of the fact was a major concern, but in case of warranty, it is not. Right? Anything which is material or not, if you are breaching the warranty, then in that case, it leads to avoidance of the policy, right? Now, warranty can be expressed or implied both, but in most of the cases, it is expressed warranty, right? The policy holder is supposed to follow the terms and conditions of the policy. Now, warranty means what? Okay, so you can simply understand this, that before entering into any insurance policy, you need to sign a few contracts, few agreements, right? So whatever terms and conditions are there, you need to follow all those terms and conditions. This particular for this particular concept of following those terms and conditions is known as warranty. If you are not able to recall the definition of warranty in the exam, then you can simply write that following the concept of following the terms and conditions of the insurance policy by the policy holder is known as warranty, right? And the second point, you can simply write that warranty should be strictly complied with, and breach of warranty can lead to avoidance of policy. And the fourth point you can write is it may be expressed or implied, because these are a few common things which we have been studying in law since foundation days, right? So there should not be any confusion regarding this, right? So do let me know whether you're clear till now or not. Okay, it is clear. So the next principle that we are going to study is principle of conditions. So conditions क्या होता है? This is basically the terms which shows you the limitations or restrictions under an insurance policy, right? When you are entering into an insurance contract, then there are certain limitations which are prescribed for you, right? So that is known as conditions. Terms which prescribe the limitations under which an insurance policy is granted and which specifies the duties of the assured. So when it comes to conditions, two important keywords are there. One is limitations and the second one is duties, right? Some limitations are imposed on the policyholder, and also there are a certain duties of the policyholder, right? So those are known as conditions. Now condition can be of two kinds. One is subsequent and one is precedent. So as the name suggests, precedent का मतलब क्या होता है? The conditions which are there before entering into a valid contract, right? Which are essential for creation of a valid contract, which means obviously it is before entering into a insurance contract, right? So that is your precedent conditions. And the non satisfaction of any precedent condition makes the contract void ab initio. Void ab initio का मतलब क्या होता है? It means that contract is void right from the beginning, right? Right from the date of beginning, the contract is void. Why? Because the essential conditions are not there. Essential conditions are not satisfied. Essential conditions which make it a valid contract are not satisfied, right? Now, what is the meaning of subsequent conditions? So, obviously, subsequent, as the name suggests, after the contract is created or after the policy has been created, then whatever things you need to make, whatever conditions you need to satisfy, all those things are known as subsequent conditions. So, subsequent conditions relate to the continuance of a valid contract. So, precedent is regarding creation of a valid contract, and subsequent conditions are regarding the continuance of a valid contract. Now, Okay, so Prajwal is asking, ma'am, from where we will get the notes? Okay, so I will provide the notes in my Telegram group. You can DM me there. But once the entire insurance law series on Unacademy is completed, then only I'll provide you with the notes. So for that, you have to attend all the classes, and at the end of the last class, you can DM me on Telegram asking for the notes, and I'll send you personally. Okay. The non-fulfillment of subsequent conditions lead to avoidance of the contract from breach date. Right? This is breach date. This is an important information that non. Okay, non-fulfillment of all the conditions, all the subsequent conditions will lead to avoidance of contract from the date when the non-fulfillment started, right? Breach date का मतलब क्या होता है? Breach date means the date on which you did not fulfill the conditions, right? So that date is your non-fulfillment date. So from the date when you didn't fulfill the conditions, from that date onwards, the contract will be avoided, right? So I hope this is clear. The principle of conditions is also clear now. So out of the 7 principles, we are done with 4 so far. Now 3 are left. Okay, this is one of the very interesting principles. So if you go to any insurance law book, then you will find these are two different conditions, but two different principles. But in our CMA book, these are given as one. So we will study one by one. First, we will study indemnity. So indemnity we have been studying from the first class only. What is the meaning of indemnity? Indemnity simply means providing protection against any loss, right? Providing protection against any loss. So it says that other than life insurance and personal accident insurance, other than these two insurance, all the contracts are contracts of indemnity, where where the insurer undertakes to indemnify the insured for the actual loss suffered by him as a result of occurring of the event insured against. Now, indemnity simply means that, uh, for example, before happening of a particular event for which I am insured, whatever was my financial position, right? If the insurance company is like getting me into the same position even after the event of happening, then that particular thing is indemnity. Which means, for example, something happened due to which I suffered a loss of 50,000, right? And that particular thing was insured. Now, after the event happened, now I lost the entire 50,000 rupees, but now the insurance company is making me cover the loss because I had done the policy. So 50,000 का लॉस हुआ, but again the insurance company covered me with 50,000. So now I am exactly in the same position where I was before the happening of the event. So this particular thing is known as indemnity. I hope this is clear. So this particular statement says the same thing. The insured is to be placed, this is very important, the insured is to be placed in the same position as if the loss has not occurred. As if the loss has not occurred. Now, in the first point, we studied that other than life insurance and personal accident insurance. Why it is said? Because obviously, in life insurance, we are insuring our lives, right? So, obviously, we cannot, we cannot. Replace the same thing. If death of a particular person happens, then the insurance company cannot bring that person back, right? So in case of life insurance and also personal accident insurance, which means, for example, Mr. X met with an accident, and due to some reason his leg was imputed, right? His leg was amputated, sorry, amputated. So amputated means काट दिया गया, right? Due to an accident. So in that case, the insurance company obviously cannot bring the body part back, right? So the insurance company cannot place the insured person in the same position before the loss, right? So that is why here it is written that Other than life insurance and personal accident insurance, all the contracts are contracts of indemnity. So here, what are the three important points? The first important point is that insurer undertakes to indemnify. Now the second important point is undertakes for what? The insurance company will indemnify for the actual loss, right? Actual loss should be there, and it should be done on the event of happening of that particular thing for which the insurance was taken, right? Occurrence must be there, right? Occurrence must be there. Now again, we know that any insurance company, I'm not saying anything against any insurance company, but generally जो इंश्योरेंस का अमाउंट होता है वो मिलने में बहुत दिक्कत होती है, राइट? देर आर अ लॉट ऑफ पर्सन्स who cannot claim the insurance amount, the insurance amount. Why? Because there are certain limitations which needs to be done, which needs to be satisfied. If all these things are there, then only the insured is going to get the insurance amount, right? So these limitations are the four important limitations. This you need to remember, because you might get any question from this in the exam. So the first limitation says that the injury or the loss sustained has to be proved. It has to be proved. So whatever injury or whatever loss you have suffered from, that needs to be proved. Second point says that whatever insurance amount you're going to get, that insurance amount is limited to the amount which is specified in the policy. For example, I did an insurance for my smartphone, right? And the amount which was specified in the policy is for 15,000, right? Now, after the occurrence of any accident where I lost my phone, I cannot ask for 20,000, because the maximum amount of insurance policy is 15,000. I cannot ask for more than that. So it is the whatever cover you will get against the loss, that is limited to the amount of that is limited to the amount which is specified in the policy. Now, the third point says that indemnified only for the proximate or exact cause. Now, this we will understand in the next principle. What is the meaning of proximate or exact cause? Because you will get the cover for the loss which is the exact cause. Now, I got this smartphone insured, that on the if my phone gets lost, only in that case I am going to get the insurance amount, right? But for due to some reason, if my phone broke, right? It fell from my balcony and it got broke. So in that case I am not going to get indemnified, because this is not the exact cause for which I was insured. I was insured for the loss, but in this case my phone got broke. So in this case I am not going to get indemnified, because this is not the exact cause, right? Now, the last condition says that market value of the property determines the amount of indemnity. Now, this is very important. This is where the maximum insurance company play the game. The market value of the property is very important, because somehow whatever amount is specified in the policy and the market value of the property, obviously whichever is lower between both of these amounts, the insurance company is going to pay you that particular amount, right? So this is also very important. What are the four limitations? The first limitation is that you have to prove whatever injury you have suffered from. Second point is that the amount is restricted to the amount specified in the policy, right? If in the policy it is written 50,000 15,000, then I cannot ask for 20,000. Now the third point says that it should be for the proximate or exact cause, right? Now the fourth point says that market value of the property determines the amount of indemnity, right? Now, Now, after the principle of indemnity, let's understand the uh, principle of subrogation. What is the meaning of subrogation? It means substitution. Substitution means इसके जगह पे ये चीज लाना, right? When one party stands in for another party, that is known as subrogation. Now, subrogation means it enables the insurance company to take over the legal rights of the insured to recover the damages. Now, this sounds very complicated, right? So, here we will take one simple example. You can see in the example that there is a person, Mr. X, who is getting his goods transported from one place to another place, right? Through a truck. This is a truck, and this truck is getting now this truck is owned by a transportation company known as a transport company, right? Now this person has an agreement with a transport company to transport his goods from one place to another. Now what happens, this particular truck met with some accident, and Mr. X suffered a loss of 5 lakh rupees due to the fault of the driver, right? Due to the driver's fault. So in this case what happens, the insurer can collect rupees 5 lakhs from a transport company. Now here what is happening, this truck met with an accident. Now Mr. X suffered a loss of 5 lakh rupees. Now somehow the like Mr. X did an insurance for this particular goods, so Mr. X got the 5 lakh rupees of loss recovered from the insurance company, right? Now principle of subrogation is relevant for the insurance company, because here in this case the insurance company has got the legal rights of Mr. X to claim that 5 lakh rupees from the transport company who owns this particular truck, right? I hope this is clear to you. यहाँ पर क्या हो रहा है, X को मिला पैसा कहाँ से, insurance company gave money to Mr. X. Now there is this A transportation company. So this A transportation company has met with an accident, like the truck of this particular transport company has met with an accident. So here what happens, the insurance company can claim this 5 lakh rupees from a transport company, right? So this particular right which the insurance company is getting on behalf of the policy holder is known as the principle of subrogation. I hope this is clear for you. Is it clear? Do let me know in the chat box, because only 4 minutes are remaining, so we are not going to the next principle. Shivani, Prajwal, Arushri, Ritvik, whoever is there, please let me know. Okay, it is clear, right? So I think we can keep the class up to here today. In the next class, we will study the next principles.